welcome back to Vidyapaka. Before starting today's class, I really wish all of you are doing good there in this pandemic. Today's class is a case law which is called Salomon versus Salomon. A very predominant and a very important case law from your company law perspective. A case which happened in 1896. Even still, it has its own prominence in today's date. So what exactly is this case law? Let us begin our today's class. Before we start, I would also like to tell you that the figures, like whatever the numbers used in this particular case law, because this being a very old one, the numbers change in every article which is published. So concentrate more on the concept and the figures are understood here. So let us begin our case law. In our case, our hero of the story, Mr. Salomon, he was a sole proprietor, the single owner of his business. His business was dealing in leather shoes. He sold leather shoes and it was a really profitable business. Every story has a twist. The same was even his story. His children wanted to join with him as business partners in his business. But as the name suggests, it was a sole proprietorship. There could be only one owner. So in this form of business, he could not accommodate his children to the business. So what did he do? Asking few people in those days, he started his own company. He incorporated a company called Salomon and Company Limited. As per those days, the number of shareholders, minimum number of shareholders were 7 in a company. To facilitate which, he took 20,001 shares in that company, his wife took 1 share and he had 5 children who subscribed to 1 share each. In total, 20,007 shares was the paid up capital of the company. Now the company was formed. What business will it do? This was the plan. His business, whatever he carried on as a sole proprietor, his plan was to sell that business to the company. Yes, he was the owner, but this is how they wanted to take over the company. So what did he do? He sold the business to the company for a consideration, money value of 38,000 pounds. And the 38,000 pounds were paid to Mr. Salomon in 3 ways. The first one was 20,000 shares of the company were given. And the second one, 8,000 worth cash was given. And the last one, the company didn't have any other money left. So they issued him something called as secured debentures. What is the secured debentures? Debentures are those instruments. If I don't have money today, I will issue those instruments and you can have it in lieu of money. Tomorrow, whenever the person wants money, he will get that instrument back and he will collect the money. In this meanwhile, he will get interest for it. Such instruments are called as debentures. What do you mean by secured? Now imagine you go and take a loan in a bank. The bank will ask you for a security, collateral. What is that? They will ask you to give a property, mortgage. Only then on that they will give you certain loan. The same thing happened here. What do you mean by that? Tomorrow, if the person is not able to repay the loan, the bank will take off his property. In the same way, if at all the company issues secured debentures, if you are not able to repay, the company is not able to repay the money, when he wants this money back, that time he will have his security over the assets of the company. That is, he can sell the assets of the company and take money, whatever he should get. That was the understanding. That is the meaning of secured. Now this entire thing happened and the company started doing business. Any company would still want more money, and the company also raised money through unsecured creditors. What is this creditors? Any person with whom you do business or you take another hand loan, these are those people, the creditors. And their claim was unsecured, meaning if at all the company does not repay money tomorrow, the creditors will not have any say in the assets of the company. This was their status. Now, As the company was functioning, even that started doing the same the leather shoe business, but the time couldn't save it. Every story has an end, so was our story. The company could not survive for a long time and it started seeing decline in its sales. Thus, losses tortured the company and finally it came and reached the stage of liquidation. What is liquidation? Liquidation is officially death of a company. So now the company was being shut down. The company had two things. One is assets and liabilities. Obviously, when it is going for liquidation, meaning the losses were high, that is the liabilities were more. The liabilities were 17,733 pounds, wherein assets were only 6,055 pounds. Now, you only see the equation, they didn't have enough assets to repay their liabilities. Now the question was that to pay the 17,733, how will they distribute the 6,000 worth assets? Now the question was, in this 17,733, 10,000 belonged to Salomon. How did this 10,000 belong to Salomon? This is what the company had to repay. Remember the first one, secured debentures. The liability was always there. Whenever he comes and gives you the instrument, the company had to repay. That 10,000 was always there. And the rest were creditors, whatever we issued here. Unsecured creditors. So these two liabilities were still there. Now, Mr. Salomon said, whatever the 6,055 worth assets are, I will take that in lieu of my 10,000 worth liability. Creditors said, how can you take that? It is your company. You should suffer the loss first. First give us the money, and if at all there is anything remaining, that you should take. That is how a businessman should work, said the creditors. Just like any other story, again, this ended up in a court. These people fought and they couldn't judge their things and they went to court. Creditors' claim was that, Your Honor, this person is not different from his company. The company and this person are one and the same. So ideally the money should go to an outsider first and then to this person. After listening to all the facts, then the judge gave his decision saying that, my friend, do not forget the characteristics of company. In the characteristics, there are two predominant things which says doctrine of separate legal entity and corporate personality. What do you mean by doctrine of separate legal entity? In the given case, once the company is formed, the company is different and Mr. Salomon is different. Salomon is not asking for the repayment in the capacity of equity shareholder, but he is asking in the capacity of debenture. It is a totally different instrument when it comes to the company. And also remember, whenever there is liquidation, the order of repayment, that is whenever the money is limited, whom should we pay first is always prescribed. The money always goes to secured creditors first. If at all there is anything remaining, it will be paid to unsecured creditors. And still if something is remaining, that will be paid to equity shareholders. Salomon is asking for his 10,000 worth of debentures which is secured. Now if after paying anything to him, if still it is something is remaining, that will be given to you as unsecured creditors. And even after that, if something is remaining, he will get the money back in the capacity of shareholder. And this is how the doctrine of separate legal entity came into picture. So what do you mean by doctrine of separate legal entity? The company is different and Salomon is different. Though he only formed the company, you cannot say that the liabilities will always belong to him. He is different for the company. And because his claim was secured, this will have a priority in repayment to Mr. Salomon. So that was this very interesting case law. I hope it clarified all your doubts. Thank you so much for watching, guys, and stay